to this week's session of Land Trust Law School. You're in Doing Deals 101, where we'll have Linda Francois and Ailla Wasstrom-Evans present out to us and, get us going on our graduation track for law school here. So without further ado, I'm going to go ahead and pull up your slides here, Linda and Ailla, and hand it on over to you to introduce yourselves and get it started. So just one moment. Can you all see the screen or no?
Nope.
No? Okay, let me redo this. Apologies here. Okay, we should see a title slide there. Are we all seeing it?
Yes.
Good. All right, excellent. Linda and Ailla, take us away.
Okay, well, my name's Linda Francois. I'm an attorney in private practice in New Haven, Connecticut. I do conservation deals throughout Connecticut, representing land trusts and landowners and sometimes municipalities. And I've been doing that for over 20 years. And Ailla, would you like to introduce yourself?
Sure. Ailla Wasstrom-Evans. I'm an attorney with the Prue Law Group. We're based in Willimantic, but we also have offices in Coventry and Brooklyn, Connecticut. I work in land conservation deals representing both landowners and land trusts, and I'm looking forward to our discussion tonight.
Okay. So the first thing you have to decide when you're doing a deal is to stay on a slide. Okay, well, I was so happy that we were doing the law school that I did this little logo, and maybe we'll make jackets for you all when you're done. There's definitely a lot of weighing going on. This is of different things. This is a gross oversimplification because from working lands to forever wild, there's a whole lot of difference, but there's a lot of stuff worth preserving. So next slide. Okay, so the first thing you have to decide when you want to look into protecting a piece of land is, what is it you're protecting? Is it about habitat? Next slide. Is it about recreational uses? Do you need access? Is it about trails? Next slide. Or is it about something, working lands, farming, the structures? There's even historic structures, but we won't deal with that much. Or are you dealing with a piece of property that has all of these things on it? You could have different areas where you have forever wild kind of forest, or you have working forests, or you have working agricultural lands, you have farm structures that go with your agricultural lands, and you have great habitat. So you got to figure out what it is you want to protect. Next slide. But and do that before you go to see the landowner. But when you go to a landowner, what you need to do is listen. You need to figure out where their head's at, what they want out of this transaction or not want. What are they receptive to? We could do a whole seminar on approaching landowners, but generally face-to-face conversation is the best thing. Go with somebody who knows them, hopefully. You make an appointment to sit down and talk with them. I want to talk to you about your land. You introduce the land trust. They may not be familiar with what a land trust does. If you have a specific project, go with that. Listen, don't spread this around. Landowners want confidentiality. Keep it general. Do not show up with a conservation easement that's 25 pages. You will scare them off. They'll take one look at it and they'll hightail it for the hills. That comes way down the list of things that you do with a landowner when you're negotiating. You want to find out what they're interested in, and figure out what the possibilities are. So, and you need to figure out what's the best way to protect this land. There's three basic conservation tool types. First is your ownership, which you're all familiar with. Legally, that's known as fee simple. It's called fee simple because there's another thing in Old England called fee tail, where it just went down to the oldest son. Fee simple, you can sell the land, you can pass it on. A deed restriction, where you say in a deed or in a declaration of restrictive covenants, something like the property can only be used for open space. And a conservation easement, which is, we'll talk about more in a little bit. Next slide. Okay, so ownership, fee simple. The land could be donated to the land trust. The land could be, the landowner could retain a life use and the remainder goes to the land trust. And this can, or the property could be sold to the land trust, or what we call a bargain sale, where the land trust pays something of what the fair market value is, but not all of it. And then the land trust owns and manages and protects the land just like any other landowner. There's an income tax deduction that's available for that. There's a whole seminar on tax deductions, but for our purposes at this point, there's a tax deduction, and some funding may be available to actually buy this property, like the DEP money, NRCS money. There's other grants that are available. Next slide. So how about a deed restriction? Let's not use that difficult conservation easement. Let's just put that in that deed to the land trust, or in a deed to somebody else, that the property has to be used for open space. Or we'll put it, I'm going to put a deed restriction on my property that's a declaration of restricted covenant saying property can only be used as open space before I give it to my nasty nephew who wants to put 10 houses on it. Problem with deed restrictions like that is, number one, what is open space? Does that mean that you can have cows on it? Is that open space? Can you have a barn for the cows? Can you have a gazebo? That's good for looking at open space. Could you have tent platforms for the Boy Scouts? Deed restrictions are usually 1 or 2 sentences.
Yeah, why are you worried?
They leave a lot of things to later discussion, which sometimes turns into later lawsuits. The other thing about a deed restriction is, so who can enforce it? If you don't have a recipient, a land protection entity that is empowered to enforce it specifically, which basically turns it into conservation easement, who's going to enforce it? Who can enforce it if somebody slaps a house on that piece of property that has a deed restriction on it? Who cares enough to enforce it? Who's going to check it to make sure that it doesn't have a house on it? And can courts undo it? And courts can undo deed restrictions if they're not technically correct. A lot of times they need to be part of a common scheme. They don't have the protection of the statutes that say that unless you're living next door and you care about it because you live next door, the easement goes away. The deed restriction goes away. If you put a deed restriction on your property, you have devalued the property. So if you later donate the land to a land trust, you are really donating it at a restricted value. Most of the value of property comes from the ability to put a house on it. if you prevented that by your deed restriction, the property's not worth much. It's a couple $1,000s an acre. And people sometimes do this and they don't realize that they are throwing away their tax deduction for giving the land to the land trust. We've been trying to create a deed restriction that could be short and usable and not complicated the way conservation easements are, because some people just don't want to go through what is involved with a conservation restriction, which I will talk about. But it's very difficult because of all these issues. It will never be perfect. Yes, if anyone has questions, please type them in and we'll address them. And next slide. Okay, conservation easement. Now I'm hoping that a number of you don't have a lot of background in conservation easements. This is 101. And I like to make sure that everybody kind of understands what we're talking about. So in Connecticut, the statutes call a conservation easement a conservation restriction. It's the same thing. The conservation easement is the federal term. Conservation restriction is the state term. Arose by any other name, it's still arose. We like to explain a conservation restriction as when you own land, you own a bundle of rights. You have the right to build a house on the property, to have a horse on the property, to subdivide it, to do nothing with it. You have all those rights to let other people use it. What a conservation restriction does is it gives some of those sticks away to a conservation entity. But so if they're giving away the right to subdivide, it's not that the conservation entity can subdivide the land, or the land trust in particular. It's more like those sticks are broken and the land trust holds the pieces. And if anybody goes to subdivide, they can hold up the pieces and say, you can't do that. We have those sticks. You no longer have them. The owner still owns the property, manages it, insures it, pays taxes, and retains whatever rights are retained in the easement. The easement is perpetual by statute. It runs with the land. It goes on forever. If you just put a deed restriction on that didn't meet the statute, that didn't have a land trust or conservation entity holding it, it would not go on forever. The only time it could go on for ever would be as if it's your neighbor's right to have a driveway across yours, because that's what they call an easement appurtenant, and it's part of the property next door. But again, that can be given away, that can be terminated. It's different than a conservation easement. The land trust that holds the easement monitors to make sure that that Dunkin' Donuts doesn't show up on the property, and it enforces the easement if it does show up on the property. Terms are different from easement to easement. Next slide. So one of the reasons you want to use a conservation easement to protect land is because it is flexible. The terms differ can differ quite a lot. You could retain the right to put a house on the property in one particular area. You could retain the right to do working lands, kind of things like agricultural uses, forest management. So it's attractive to a landowner. They get to retain some rights. It's attractive to the land trust, or at least some land trusts, because they've got basically a resident caretaker protecting the property. As long as it's not the fox guarding the hen house, it can be a good thing. A conservation easement can be put on while somebody's alive and owning the property. It can be put in their will so that when they pass, the easement goes on, or it can be put on actually by their executor. It's a lot more complicated once you're dead to put things on and to do them right. So it's a lot better to do it during your lifetime, or at least to flesh out all the details before it goes in your will. Conservation easements can be deductible. against your income taxes. The IRS has strict rules on what this is called a partial gift. So you have to follow their rules. If you don't follow their rules, they are not deductible. So those deed restrictions are not deductible because they don't follow IRS rules. And funding is available for some conservation easements, in addition to that nice tax deduction. Next slide. Okay, so why not to use a conservation easement? Why don't we use those all the time? Well, it's not appropriate if the land trust wants complete control. If they're going to have, say, a lot of trails, or they want other kinds of active uses on the property, or it may not be good if they want to make sure that nothing goes on the property. Forever wild, even though we have forever wild easements, those actually can go on sometimes when land trusts own them. There's not a whole lot that the landowner has as an incentive to hold on to the property. Conservation easements are complicated. Once you understand them, they're not as complicated, but they are complicated, and you can have different terms for different people. The landowner who owns the property does have a high incentive to violate them. The initial landowner who voluntarily puts a conservation easement on for whatever reason usually is pretty well okay with the terms. They're familiar with the terms. They know, they hopefully planned ahead. But the subsequent landowners have a high incentive to want to stick that shed up, or that studio, or the barn where it's not supposed to be. So that is a problem. It's not as good as the land trust owns the property and nobody has a right to build anything on it. And when you put on a conservation easement, the donor or landowner is giving up value. They're limiting the pool of potential purchasers. Some people do not want a piece of property where somebody else has restrictions on it. There's also a lot more transaction costs and more requirements. That's the yikes part on there. Next slide. So what are those complications of a conservation easement? S&P is short for Standards and Practices. The Land Trust Alliance has standards and practices regarding doing these kind of deals. The IRS has requirements about deductibility, but a lot of these requirements are common sense for this kind of restriction. All those problems we had with those deed restrictions, they've tried to iron them out in a conservation easement, and that's why they're so long. That's why they have so many terms. They have things like baseline documentation, which is a requirement that the land trust create a set of documents showing the condition of the property at the time the conservation easement went on. So it both tells the future courts or whoever's interpreting it why you're doing what you're doing, why you're protecting this land. And it also tells them that there's not a Dunkin' Donuts on this piece of property at the time it was donated. So if one sprung up later, odds are the landowner put it there and it's an encroachment on the property. It's an easement violation. You have to subordinate any prior mortgage. So if there's a mortgage on the property, so we've got a landowner, they're trying to protect the land with a conservation easement, which is going to give them a nice tax deduction and also leave a legacy of conservation. If they have a mortgage on the property, they either have to get the bank to say, we're going to come behind the easement. We can't close out the easement if we foreclose on you. That's what subordination means. Or the landowner has to refinance and get a mortgage that's behind the conservation easement so that the conservation easement is not subject to getting foreclosed if they stop paying their mortgage. Now we know it's pretty unrealistic that these properties are going to get foreclosed. It doesn't happen that often, but the IRS is all about perpetuity. They're all about making sure this easement that they're giving you a tax break because of goes on forever. Now, that's not a bad thing. I mean, the land trust wants to make sure that it goes on forever too. So there's other required boilerplate. Incidentally, I like to tell people, I think this is cool, that boilerplate is when newspapers used to be printed with machines. They had these metal sheets that had the masthead, the name of the company and all that, that looked like the sides of a boiler. There were these big metal plates, and they would stamp everything with those plates. So boilerplate is the stuff that we put in every easement. It doesn't change. One of those is extinguishment clauses. And it's important for you to know this stuff, because at some point, if the landowner looks at these things, they're going to go, what the heck does this mean? And it's really good if you can just whip out the answer. Oh, that's easy. That just means this. So extinguishment terms in an easement, and clauses in an easement that say that if the property is ever condemned or taken for eminent domain, and the landowner gets paid for the value of the property, the land trust gets their share of the value, because that value was given away when they gave that easement, and therefore that the amount of the money that's attributed to the land trust rights, those sticks that the land trust holds, they get that money. And that way this easement is still perpetual because the land trust is still holding the money. So that's a clause that's in there. It's about a page and a half long. People never understand it. You have to have a clause that says you give notice before you exercise a right, which would have an adverse effect, or could have an adverse effect on the things that you're protecting in the easement. Those are what we call the conservation values. Sensible. That way the land trust can say, wait a second, you're not allowed to do that. Yes, you can build a house, but you can only build it in this section, which is not key habitat, or, that sort of thing. There's amendment clauses, assignment clauses, so that the land trust can assign it to another land trust if they need to. There's required merger clauses. Merger is another thing that people have never heard of before. They don't know what it means. And that's, remember, we got a bunch of sticks in one hand and sticks in the other hand. Well, if the land trust is the easement holder, they're holding the sticks of the easement, and the landowner decides to leave them the property by will or sell it to them, the land trust is now holding all the sticks. And under old, what they call common law, if you're holding all the sticks, the pieces go away, you hold everything, and the restrictions are gone because you have all the sticks. Now, under Connecticut law, that really doesn't happen, because our statutes say that there is a public interest in those rights, so that the sticks never merge. They may come together, but they never merge, because the public still has a right in those easement sticks. They don't have a right to do anything with them, but there's a public interest in them. But you still need the merger clause. So, but the great thing is that CLCC has created a model conservation easement, and that incorporates a lot of this stuff. Pretty much, it has all the boilerplate in it. So you don't have to worry that this stuff is wrong. I mean, the IRS can attack anything. There's never any guarantees. They're always trying to find a way to put a hole in an easement, because they hate to give deductions. But we've done the work for you. So at least the basic boilerplate is in the model easement. And the reason the model was created was so that we wouldn't have a whole bunch of formats that were missing important pieces. And the law is always changing, so we try to keep that updated. A conservation easement must be to a qualified organization, which is either a land trust or a municipality. You actually, whenever you get a gift, and that includes fee simple gifts, monetary gifts, if they're over $250, you have to give them that no goods or services letter that says no goods or services were received in exchange for the gift you gave us. Even though you have a 25-page easement, you're still supposed to have that letter. And for the landowner to take a deduction, they need a qualified appraisal. These are pricey. I mean, you're talking thousands of dollars, $5,000 or more to do a good appraisal, depending on how big the property is, what are the complications. Generally, the way conservation easements are appraised is, so we've given away those sticks. So what they do is they appraise the property as if it's all together. All the sticks are together in the landowner's hands. And then they appraise it with the sticks removed. And the difference is the value that is deductible and is the value of the gift. They're starting to be able to have comparables of conservation easements because there's so many out there, but they didn't used to have enough comparables to say, well, you know, I have three different properties that have conservation easements on it, and this is what they sold for. And easements are so different, different terms that they really aren't things that you can compare. So the only way they could appraise them is before and after, when the difference is the amount of the gift. So those are the complications of conservation easements, but they still may be the best tool for the project if the landowner wants to retain ownership of the property and the land trust still wants to protect the property. Next slide.
Linda, before we move to the next slide, I actually did get a question in the chat. And the question is, what actions or tools can the group holding the easement take if there is a breach, i.e. if someone does decide to build a Dunkin' Donuts?
Well, I do have a little slide on that later. We have some really good statutes allowing you to sue the person, the encroacher. And we've got some terrific statutes on that. I'm going to put that off until we reach that slide, okay? So it's Ailla's turn to talk about due diligence in land transactions.
Okay, so we're going to shift gears here a little, and I do just want to apologize in advance as my children are going to sleep right now. And so if you hear the noises turn from good to bad from my children, I apologize. It's bedtime. So please bear with me and them. So now we're going to turn over to due diligence, which for the researchers in you, this should be appealing. So basically what, big picture, what due diligence is when you're acquiring a property, or if you're acquiring an interest like a conservation easement in a property, you want to make sure that you know what the status of that property is, what its condition is, what its meets and bounds are, ownership, all of that. So that's big picture. And so you want to sort of hammer down into these issues one at a time. So first we're going to go to the title search. Next slide, please. So I'm sure many of you are familiar with the Land Trust Alliance's standards and practices. And so one of those standards and practices is 9F, which requires title work and documentation as to how any title related issues were addressed. So basically title work, what that means is that means a title search. And I strongly recommend that you engage an attorney or a title company to do that title search for you. Title searches are only getting more and more complicated. It's the indexes are difficult to decipher, and it's hard to know that you're getting every single document. Even for the most experienced of title searcher, there's still errors. So I highly recommend that you engage either an attorney or title company to do a title search for you. So what's that title search going to show you? How are you going to read that title search? One of the first things that's going to come up is who title is vested in. And so what that is ownership. So there's all sorts of different entities that could own a property. Could be your ideal world is it's one owner, or it's a husband and wife and it's straightforward. But we don't usually get the ideal situation, of course. So there could be multiple owners. There could be an LLC, a corporation. It could be an estate. It could be a trust. And all of these different entities carry with them their own baggage. And so, for example, if there's multiple owners, let's say there's multiple owners and multiple parcels and different owners of different parcels, that could be really complicated, because what happens if one of the owners changes their minds and says, I want to pull my parcel out of this deal, and then you're starting all over, basically. So multiple owners can really be tricky, especially if they're not on the same page. Sometimes they all are. It's family. Everybody's clear what they want, but it can just raise complications. Then there's issues with LLCs and corporations as well, needing to make sure you get all the proper resolutions and whatnot from those entities authorizing the sale or the easement. With an estate, there's all sorts of complications, again, making sure that there's no liens associated with that estate. So basically, when you see the ownership, you will just keep in mind there could be some red flags if it's anybody other than a single owner, just for some additional, steps that are going to have to be taken to make sure that the transfer of that interest can go through to you completely. Go back to the last slide. Yeah. So the other thing, and this seems straightforward, that the title search is going to show you the property address, but with the kind of land we deal in, this is really important, because a lot of times the kind of land we deal in isn't like 17 Elliott Road. It's, map block lot number, blah, blah, blah. So you want to make sure that you're searching the right parcels. So get your correct map block lot number in there, check the title search, make sure you've got the right property, because obviously that's very important. And your title search is also going to include tax information as far as property taxes. You don't want a whole gigantic mess of unpaid real property taxes on the records there, because basically the municipality could have a tax foreclosure sale on the property because of those. And then any interest you have in the property could be terminated if that wasn't resolved in advance of the transaction. Next slide, please. So the meat of the title search is really going to be the encumbrances. And so what an encumbrance is basically it's something that's put on a property that has a negative effect on it. So basically all of these things: mortgages, lease pendants, liens, restrictive covenants, license, saying subject to conditions in a map. These are all examples of an encumbrance, which basically means the property is subject to certain title related restrictions or issues. So in a mortgage, it's basically the property is the collateral that's securing a note. So that means it could be foreclosed upon, like Linda had talked about during her presentation. So basically the easement could, if you're seeking an easement and you don't get a mortgage subordinated, that could be problematic in the future in the event of foreclosure, because the easement could be extinguished. So mortgages need to be dealt with either subordinated, paid off, or refinanced. Lease pendants, that means there's litigation pending. That's a messy situation that, you want to make sure you're not falling into. Liens, there's all sorts of different liens on property. Like I mentioned, there's property tax, there's estate tax liens, there's judgment liens. Again, these are all foreclosable interests that could jeopardize any interest you take in the property. So these are going to want to be cleared up before any transfer into the land trust occurs. Restrictive covenants and licenses, that just shows you rights that people sort of have or don't have. So the restrictive covenants basically showing you there's already these restrictions in place on the property. A license is showing you some people have rights to do X, Y, and Z. A lot of times in title searches, you'll see subject to conditions in a map. So then you need to go find the map and see what those conditions are. So make sure you go and look at that map, because there can be real devils in the details there. I had one where it said, look at the conditions in the map. And then I went and looked and there was no access to a road. The person needed a right of way to get to the road. So it's important to look at those. The other thing, in addition to that, though, there could be pre-existing easements on the property, right? So you want to make sure that none of these easements are going to conflict with, if you're taking the property in fee simple, what your plans are, or if the property is going to be subject to an easement, any of those. So for example, is there a CLMP easement that allows for, power lines to be put, through the property here and there? That's going to be problematic if you're putting a conservation easement on the property, unless that area is excluded. So these are just things that you want to think about as you're looking through a title search, and understand that these are issues that you're going to need to, have worked out or resolve in advance of the transfer. Next slide, please. Title insurance. So this, is a big question for land trusts, whether or not to purchase title insurance. So first of all, it's important to understand what title search is. Title insurance is. So basically what title insurance is it's an additional layer of protection for you. That's basically saying that whatever that title search says about the property, that is what the title search is protecting you from. If there's something else that the title searcher didn't find on the land records, that title company will defend you against whatever that is. If there was any kind of fraudulent transaction that occurred that wasn't known at the time of the transaction, that title insurance company is going to protect you against that. If there was an error in closing documents, title insurance is going to protect you for that. If there were filing errors, and this is unfortunately happens sometimes, like if a town clerk didn't record it under the correct name or something, so something's buried somewhere, again, this is going to protect you. So title insurance, in my opinion, is much more important if you're taking the property in fee simple. So if you're going to own the property outright, absolutely get title insurance. If you're talking about an easement, then it's sort of a judgment case by case whether or not title insurance is worth it for you, because it can be expensive. So you really have to weigh the costs and benefits and decide whether or not that's something that you need. Another benefit that you can get in title insurance, and again, this is going to depend on what title company is providing the title insurance, but there's various levels of survey coverage that you can get if you have a survey. So if you have a survey that's being recorded, that's terrific. You can get much better coverage for your title insurance to protect against encroachments. But if it's an old, outdated survey, then chances are the title insurer is not going to use that. So I had one from like 1986 the other day, and the title company said they won't issue survey coverage for a survey that old. So it's something that's worth looking into, but it's a little bit trickier to get the title companies to give you that coverage. Next slide, please. So the next area of due diligence is the survey and the legal description. So again, turning to the standards and practices, a survey is not required, but you must determine the boundaries. So if you're going to do a survey, make sure you have an A2 level survey. But if you're not going to do a survey, I'm sure many of the land trusts out there have great experts who can sort of do the work to figure out the meets and bounds. So that's really the key thing, is making sure that you understand the meets and bounds. Again, the best way is a survey, but if you have experts that are part of your land trust, it's possible that a survey isn't necessary. But what are you doing here with the survey? You're trying to find out, are there any encroachments? Because that's going to be a problem that you're going to have to deal with if you take ownership of the property, or if you have an easement. If there's an encroachment and it violates the terms of the easement, you're on the hook for that problem. So you don't want to take you want to know before, what are the issues? Okay, is this an issue I'm willing to deal with and work with, or is this a huge issue that I don't want to deal with? So that's why the survey is really important, or having experts that, know how to find these issues. Boundary issues too, so many of these properties that we deal with are old properties that have been in families forever. And so, the boundary marker is the old oak tree. And obviously that old oak tree is not always there anymore. So boundary issues come up a lot. And sometimes, the boundary lines aren't known, and there needs to be a boundary line agreement between abutters to clarify what those boundary lines are. The survey will also show you the location of all the rights of way. In the survey, you can establish the bounds of an easement exclusion area, like Linda was talking about earlier. So if you have an area that you don't want the easement to apply to, you can neatly map it out so that it's clear that the easement's not going to apply here. And then the survey will also show the location of the existing buildings and improvements on the property, which is very helpful in the future when we're looking to see if the easement itself has been violated. And again, like I mentioned before about the age of a survey, you might find an old survey on the land records. You really want to be cautious with relying on an old survey, because a lot can happen between a period of years. So don't necessarily, just because you say, oh yeah, I have an A2 survey, if it's outdated by even a year, things could change. So you need to make sure to update and take a look and make sure things are what they are.
Ailla, I'm going to jump in here with a question. And
Sure.
this actually goes to your previous slide on title insurance.
Yep.
And I have to say, I was distracted by looking for standards and practices. So maybe this came up and you already answered it, but I doubt it. Can you speak to buying title insurance for donated properties? At what value would you recommend?
Yeah, so determining the value. I mean, presumably you're going to do an appraisal of the property, even if it's donated. So that could give you an idea of what the value should be for that title policy if you do an appraisal. If you don't have an appraisal, you could engage a realtor to do a market analysis, where the realtor could give, it's a less costly way of determining fair market value of property. And you could base, the property value based on that. So if this is a fee simple acquisition, donated acquisition, and you're trying to figure out the value of that title, what the title insurance value should be for the property. If you have an appraisal, use that. You could get a realtor to do a market analysis, or you could also look to the assessor card in the town's records and see what the town assessor has it appraised at. Those are not the most reliable of appraisals. I find that they skew wildly in either direction. So that may not be the most reliable, but it's something, if you don't want to spend money, it's something to look to. All right. Which brings us to our next slide of the appraisal. So if you're purchasing an easement, it's strongly recommended that appraisal is conducted. If you're purchasing a property outright in fee simple, a market analysis by the realtor may be enough. Purchasing the reason why I say purchasing an easement, an appraisal is helpful. Easements are hard to put a value on. Even, some appraisers won't even do this kind of work because it's tricky. You need a qualified appraiser who understands the nature of these things, because they're unique. They have their own sort of qualities that appraisers, not all appraisers, understand. So it's important to be very selective when you're retaining an appraiser. Make sure you have somebody that knows what they're doing and can tell you, oh yes, I've done these types before, and make sure that they have, done more than one when you're selecting an appraisal. And then keep in mind, and Linda talked about this, that just because you're doing an appraiser, the landowner may need to do their own appraisal at the end if they're seeking a tax deduction. If they're not, it's not necessary, but just keep in mind, if the landowner is, they're going to need to do their own appraisal as well, which, as Linda mentioned, can be very expensive. Next slide, please. So the next category is environmental due diligence. So this is basically determining what the environmental state of the property is. This is also a very important issue. You don't want to accidentally find yourself owning a property that is contaminated. So there's all sorts of ways to do this due diligence. Talking to neighbors is really helpful. Talk to, knock on the doors, ask, do you know anything about the property over there? Its history. People, know a lot and like to talk. So it's always good to talk to neighbors. Doing a site walk is essential. You can see a pipe sticking out of the ground and know there might be an underground storage tank there, right? So doing a site walk, or you might see a pile of tires, like one tire sticking out of the ground. What does that mean? Are there buried tires under there? Possibly. So doing a site walk can really reveal a lot. The Department of Energy and Environmental Protection also keeps a list of contaminated or potentially contaminated sites on their website that's searchable by town. So you can take a look at that, see if the property is one of those, or if it's abutting one of those, then you might be concerned too. I also strongly recommend that you do a municipal search. You can engage a title company to do a municipal search, or you can do it yourself. I think you can really do this kind of thing yourself. But the problem right now is many town halls are closed due to COVID. And so it's really hard to access some of these things. But doing this, going to the town hall, looking through the building department files, the zoning files, the health department, going through all of these things, you can really learn a lot about a property and find out, if there's any records of an old underground storage tank, because that's really one of the big issues that can come up in this context. Lastly, there's always a phase 1, which is a much more advanced investigation, basically, that where you hire an environmental firm to investigate current and historic uses of the property. These are expensive. So this is most likely not happening in many instances, but it is an option. Next slide, please. Next, I just have an excerpt from the LTA standards and practices on environmental due diligence. So basically, this is the standard that is expected of you. Basically, conduct a preliminary environmental investigation, transaction screen, or phase 1 to identify whether there are conditions that pose environmental risks and take steps to address those concerns. Next slide, please. So why are we worried about these things? So basically, we're worried from a liability perspective. So in the easement context, you're more protected if you're using a wonderful easement like CLCC's model easement, because there's a great indemnification clause in there that basically protects you, because the landowner still owns the land in that situation, right? So the easement, like I said, includes a clause that basically protects you and says you're not on the hook for that. However, if you buy a property in fee simple, or if you receive a property in fee simple that's donated to you, you're on the hook for whatever is wrong with that property. So here, as a picture I have of an underground storage tank being removed, it's expensive. Cleanup from these is expensive. I just had a client who had one on their property, and it was barely any contamination of the soil, and it was just shy of $20,000. So, and that was, like I said, barely any contamination of soil. So they got very lucky. So that's very expensive, not something you want to find yourself in. So that's why this is so important. Next slide, please. Oh, I think that might be the end of my slides. So that's everything for due diligence. I'm happy to take questions on any of that, but that's sort of the big picture as far as what your due diligence roles are.
Okay, I guess it's back to me. So we have these great resources that CLCC has created. One is a conservation easement, and there's a commentary that goes along with it that explains all the different provisions. So if you've forgotten what an extinguishment clause is all about, you can look in there. There's also a compilation of options. These are new things, so that you can do some variations to the easement. It gets a little tricky when you're into the options. And these are only some of the options, because you've got as many sticks as you could possibly have, and they could be all different kinds of things. But these are some basic things you could look at, and some basic clauses that you may want to put in, to have trails on the property, things like that. We've also created a forever wild conservation easement. This is an easement that says that the goal of the Forever Wild Conservation Easement is to get the land back as much as possible to before human habitation, European settlement of the property, and to maximize that old growth, to hopefully get it back to old growth forest eventually. So it's very limiting. It has a very different feel to it than the regular conservation easement. Or open space conservation easement. Similarly, there's also an agricultural easement, which has a very different feel from the open space easement, because the agricultural easement is about working lands, about the things that you need for working lands, which are structures and equipment and things like that. So it's a very different thing. These documents are a great kind of checklist for you to go through. You go through them and go, oh yeah, that's a good idea. No, I don't want that. Oh, this really doesn't fit. We need to add this. You know, there's a lot of other stuff that could be added into easements, but if you look at these, at least you get the basic format, you get the boilerplate. But as I said, don't hand these out to the landowner the first time you go to see them. You know, they're going to take one look at these things and get frightened off, and they don't need to be. Next slide. Okay, because the structure of model easements, once you understand the structure, these things are not scary and they're easier to understand. The standard structure, which is taken originally from model easements that were used back when easements first started, or the first part of it says who the parties are, who the people are. That's the first paragraph. Who the owner is, who the recipient of the easement is. Then there's a section called the recitals or the premises. And this says all the reasons you're protecting this land, and which are the conservation values. What are the conservation values of this property? It speaks to the future, to anyone trying to interpret this document. Why are we doing this? What is it we're protecting? And so that section is about that. I'll get to the questions after. And the next section is a general purpose clause to protect the property, to keep it in its open condition. And that's kind of the foundation of the document. The conservation values are more of the specifics. And then after the purpose clause, there's a definition section, because the devil is in the details on these things. What is a structure? What is forest management? What are these terms that are in the document? So the definition, or what is agriculture? Is agriculture only growing things, or is it having livestock? So you need to look at these things, see if they apply, tweak them as necessary. But that's the next section. After that is the scary section. This is blanket restrictions. You can't do anything, because we can never figure out all the different ways people can do something evil to the land. So we pretty much prohibit everything, and then we give back rights. So the blanket restrictions: you can't ditch, dike, drill, fill, put up any structures, do something to the water course. There's these blanket restrictions, very scary to a landowner. But then there are the exceptions. The next section is the exceptions, the landowner retained rights. So despite all those blanket restrictions, what can the landowner do that are exceptions to that? And that's really the guts of these easements as far as the landowners is concerned. And when you get to the point where you know what the landowner wants, you've kind of tailored something to their purposes. You figured out what tool is correct, and in this case, it's an easement. You can explain to them or their attorney that the important thing here is that you retain the rights you want, and we put all the things you want into this document. You know, the restrictions are just everything that is not an exception. And then after that, there's all this IRS required boilerplate that we talked about earlier. So if you understand the structure of these things for you as not landowner, but land trust practitioners, you can make sense of them to people when you need to, and they make sense to you. And you can also figure out what you need, what sticks you need to hold. There's also a section on enforcement rights, as I put on the list there. So the land trust has the right to enforce this easement. And I think we had a question about enforcement. We'll get to that. So that's the structure of the model easement. Next slide. There's the one I wanted on enforcement. So I think there was a question about how do you enforce easements? There's a lot of different ways to enforce easements, but we have the best statute, I think, in the country on enforcement of easements, and that's this last one there, 52560A, where the courts can award the cost of restoration, including management fees, attorney's fees, and up to 5 times the cost of restoration. And then the Attorney General can help you enforce this. So Keith Ainsworth does whole seminars on this, but if a landowner has insurance, you can often get their insurer to pay for restoration. We can use the guide to tree appraisal. I don't know the name offhand. Basically, if somebody comes in and cuts down a bunch of trees, you can get them to pay for the cost of growing those trees back up to the age they are at. Or at least that's your goal. So we have really tough statutes here. You don't have to be afraid of enforcing easements or protecting land that you have in fee, where somebody comes in and cuts down trees. Keith just did a seminar on tree law. I'm sure he dealt with some of this in that. Then you can listen to it on tape eventually. The Attorney General has a right to enforce the public interest in conservation easements under our statutes. And they also can represent the public interest in charitable gifts. So if somebody donated property to you, they can enforce that. And any estates which were given for charitable use, the AG can enforce. Now, the AG doesn't always want to enforce things. The land trust as an owner of property can enforce these things, and as an easement holder can and go to the courts. So you don't go to the courts directly. You start by sending them a letter saying, that's our property. We need to discuss this. You've encroached on our property. And by the way, here's this statute. I know my little land trust in Bethany, we have a piece of property that had a right of way to it, and the neighbor put a stone wall across it. And we sent them a letter and a copy of 52560A, and the stone wall disappeared. So it's very powerful stuff. It's very powerful stuff. I don't know if there's another slide. Yep, that's about it. So questions? We have about 15 minutes left.
So Linda, there's one question here, unless I missed another. And yeah, and I would say everybody can, put your screens back on and raise your hand like this, or raise it with the Zoom function if we miss you. But the question came in, can you comment on easements that put an obligation on a land trust, such as mowing a field in perpetuity, are there situations where a land trust can get out of this obligation?
So the land trust has an obligation to mow it? That's,
Easements that put, yeah, so the land trust has an obligation to mow a field in perpetuity. Are there situations where a land trust can get out of this obligation?
oh, that's an interesting one. Usually easements give land trusts the right, but not the obligation to mow. And that's generally how we do it now. There, as I said, the easements can be very different. So
Could it be by agreement, Linda? I mean, certainly between the landowner, I mean, they can release that by agreement.
yeah, it could be, it's possible it's an affirmative obligation in an easement to mow. We're starting to try to do that with landowners, require the landowners to mow. But generally we don't, we're smart enough not to obligate ourselves to mow. It's always been somewhat of a question in my mind, and I don't think I would want to go there, but easements tend to be negative. They're prohibitions. It's a little outside of the scope of, that bundle of sticks, because none of those bundles of sticks is a requirement to mow. But you're seeing a lot of more affirmative obligations than you used to. And I know other states are enforcing affirmative obligations. Yeah, you definitely could change it by agreement. I don't know. Ailla, any thoughts?
Yeah, I mean, I was thinking, I just worry a little bit about changing it by agreement. Do you need to get the Attorney General involved if we've got, a charitable easement here? So I would even be a little worried about just doing it by agreement.
I did. I'm sorry, Linda. I didn't mean to cut you off.
Go ahead.
I was gonna say, I see John's hand up, but I did get a question in the chat earlier, sent directly to me, and it's please comment on the strategy of getting a conservation restriction first, and then getting fee ownership at some point down the road when the owner is currently a bit ambivalent about giving up total control rights now, and what those tax implications may be.
So can I just interrupt before you get to that, and we can go back, but John was the one who asked the question about the mowing. So maybe
about that.
Okay, fill us in, John.
John, why don't you ask that, and then we'll go to that next question so we can kind of wrap up that discussion.
Yes, I'm with Joshua's Trust, and it's not a hypothetical question. We've got several of our conservation restrictions require that we mow. And in some of these cases, you mentioned, Linda, that by mutual agreement. Our agreement's not with the current landowner. Our conservation restriction was with the previous owner. So it almost in some ways doesn't matter what the owner says. And we don't, we're often not in a position to have an agreement with the person that put the restriction on the land in the first place. They're gone.
Yeah, no, I think we were thinking about with the current owner to modify this. Was it an easement or a deed restriction or?
These are in easements, and we don't love the way they were written now in 2021, but there they are. They're in the record.
Yeah. We've all got ones that we wish we had written differently, or somebody else had written differently. We've got some terrible easements. That's one of the reasons we developed the model, is to try and get some of the bad stuff out. I think you have to talk to the Attorney General, but I think there is somewhat of an argument to be made that that this is really more a contractual agreement than an easement, and it shouldn't go on forever, or maybe that times have changed. And you're not able to do it. I'm assuming this is costly and difficult to do, difficult to get people to do it.
Sure.
I think you should talk to the AG and see what they say about it. Because it is somewhat outside of a conservation restriction, which is a restriction on use. This is actually an affirmative obligation. And what's their position on that? I don't know. Be interesting to hear, though. And maybe it's just an amendment that needs to be made, or modification, or something. I don't know, but I would say talk to the AG. Sorry,
Thank you.
no magic bullets.
And just so you all see, Amy did say to, connect with us to make sure we connect you to the right division of the AG's office. So just send either myself or Amy an email. So I'm going to repeat that question again. Apologies for the mix-up. And then I think that might be our last one, since we do want to wrap at 7:45. Again, I just want to mention to folks, we'll be back here on Thursday at 6:30 for an open Q&A on advanced topics around doing deals with Linda and Ailla. So that question again is, please comment on the strategy of getting a conservation restriction first and then getting fee ownership at some point down the road when the owner is currently a bit ambivalent about giving up total control right now, and what the tax implications of that may be. A
lot of people are doing this. A lot of land trusts are doing it. A lot of savvy landowners are doing this. And not so much because they're afraid of giving up control, but because it makes a lot of sense. The deduction for conservation easements is actually more favorable than the deduction for an outright gift in many ways, because you can carry forward the deduction for 15 years instead of 5. We didn't get into the guts of tax deductions, but it can be quite favorable, and it's not a bad thing for the land trust. There was a time that we really didn't want to get all the sticks in one place because there was this fear of merger, but it's pretty well settled, I think, in Connecticut at least, that there is no merger, so the land will stay subject to those restrictions, even though the land trust is owning them, and the restrictions are held by the land trust, guarding itself against doing these things, but the AG will enforce these restrictions, so they still stay in place, and you can convince the landowner that they stay in place. And it has the virtue of making sure that they can get their tax deduction. They get the value of the easement, and when or if the fee simple is given subject to the easement, they can get that remaining value as a tax deduction later. It works pretty well, and a lot of people are doing it. From the land trust perspective, it's not a bad thing. And from the landowner perspective, it's not a bad thing either. They can leave the property to you in their will. A lot of people do that.
And I would just add, just, be prepared to just have a conservation easement on the property in the event the landowner changes his or her mind, or, something else transpires. Just before you move forward with that, just be prepared to just be, the easement holder, because the final deal may not come to fruition, and it may, but just be prepared to just be an easement holder.
Yeah, you want that easement to stand alone as something that you want. For sure. It's a good point. Yeah. Any other questions? Oh, David's got a question.
Oh, David, you're on mute. If you can just go ahead and
okay.
There you are.
There you go. Okay. I just can't type very well with one finger. I know you're coming to the end, but when when someone gives you either an easement or property in fee as a nonprofit, okay? And let us say that it is a total surprise, just it comes out of the sky, it hits you on the head. Because you are a nonprofit and because it is given to you, do you have to keep it?
How is it being given? Is it through an estate?
Yeah, it's given, it's in will. A will, had no idea that was coming.
Yeah, you can
And
disclaim.
what do you do? What do you do with it?
You can disclaim anything that's given by way of a will. There's an option to disclaim. So if it's not something that you want to take, then work with the estate to disclaim that, whatever it is.
And
Like even a certificate of devise, just here it is.
Already reached that phase.
Pardon?
They're already at that phase where a certificate of devise has been issued.
We're 15 years beyond that date.
Oh, yeah.
And
Time.
so are you interested in selling it?
Well, we're debating it. We're debating it, and not so much selling it, but or maybe transferring it with a conservation easement on it. And probably shouldn't get into too many gory details, but it's a working farm, and owning a working farm is a lot more fun than you can imagine. And the question becomes, if we were to say, you know what, we've got 600 other acres of land that we got to attend to. We've been told unofficially that you can't give it away, that the Attorney General will not let you sell it with a conservation easement, of course, protected. Okay. But once you've got it, you got to keep it. And I just find that difficult to believe.
You should definitely talk to the AG and make sure that is what their approach. But yeah, once that statute of uses, once it needs to remain to the charitable intent that it started with, that first statute that was referred to, I think it's 42.2 or something like that. Yeah, you might have to do that, but you might be able to find some other entity that's willing to hold on to it. Or the AG might be willing to work with you on passing it on to some other entity with a conservation easement, maybe to the Connecticut Farmland Trust or something like that.
Yeah.
But whatever money you make from it most likely has to go with the property.
Oh yeah, and we're nowhere near. We're nowhere
for it.
near making that. Not that we'd ever would make that decision, but I'm tickled a little bit about the discussion of haying. It's getting more and more difficult to find somebody in Connecticut, at least our part of Connecticut, to cut and bale hay, even though horse owners who are demanding of very good hay, dairies, how many dairies are left? It's a skill that is becoming very difficult to find. And if you take on that responsibility, that, you better be careful about the responsibility that you're taking on, because it may be tough to find somebody to do it.
Yeah, look before you leap and be careful about what you promise.
That's right.
But for other people, there is a statute which allows you to basically disclaim any property you get that nobody got you to formally accept, because there is a land trust in the eastern part of the state that got given a lot of land that it didn't want at all. And so they had this statute passed, so that on gifts of land, there is supposed to be an acceptance by the land trust. Otherwise, the gift is voidable. Too late for you, but I don't think that statute goes back as far as what you have, and you're pretty far down the road. But if anybody gives you stuff when you're not looking, you don't have to keep it.
Who gets it? Does it sheet to the state?
No,
It just voids the transfer.
Yeah, so then it just passes. If according to like, if there's a will pursuant to the residuary clause.
To
in the
everybody
will.
else.
If there's no
Okay.
will, then by the laws of intestacy.
Yep.
But even
Interesting.
if somebody just quit claims to you a piece of property and records it on a
Yeah.
land records, which is what happened in this case, that is avoidable transfer. You're not stuck with the property.
So on that note, it is we're approaching 7:50. We did we do want to wrap at 7:45 out of respect for everyone's time. I've entered in a link to sign up on Thursday. Again, we're having an open Q&A session with Linda and Ailla. So if these questions have sparked your own questions about your own properties, please bring them with you. I've also put Amy's email in the chat, not because I don't want to receive your emails, but because she can direct you to the AG's office better than I. With that, I do want to say thank you so much to Linda and Ailla for joining us, and hopefully you're still willing to come back on Thursday to see us again.
Work towards that diploma.
Yes, absolutely. And any additional questions, feel free to email me in advance too, if you have them in advance of Thursday. But with that, I just want to wish everyone a great night. Yep, and Amy noted if you have questions about the model conservation easement, bring them on Thursday too. So enjoy the rest of your evening, everyone. Get that last bit of sun in, and we'll see you later in the week, I hope.